Good morning, everybody, or good afternoon. It's noon. Welcome to the SAME Small Business Community of Interest webinar. And the subject today is the SBA Recertifications and their impact on small business. Just a couple housekeeping notes and tips. Those that are connecting through a VPN, you may have some difficulties. Please ditch the VPN. The audio is broadcast through our computer speakers. When you entered, you should have been prompted to connect to them. Please use the chat on the top right-hand side of the panel to submit any technical issues. And there is a private tab for that if you would like to. We will send it to you directly. And you are welcome, and we really are encouraging you to submit your questions on the Q&A tab. As soon as you see the subject and the question pops into your mind, our speakers today have been very graceful, and they would be welcoming questions throughout the presentation. So that will make it a very interactive session, I'm hoping. And this webinar is being recorded for future viewing. We have a poll question for you, if you could help us out, and this will help the team understand who is on the call. Okay, and we'll give it a second to see the answers. So no surprise, we have about 21% are small businesses on the line, and about 75% are medium businesses. So those that are either advanced smalls, or as SAME rates them over 100 employees, we consider them small business, medium businesses for SAME. And I'll wait till it closes just to give you a final. I think we're good. Okay, next. So the subject today is the SBA recertifications and their impact on small business. And we have two presenters, and I'll walk you through the three of us. I'm the moderator. It is truly a pleasure to moderate a session by Pilero Maza. We think very highly of the firm, and we've actually engaged your services for the many years, for about 18 years to be exact. So thank you for giving us your time and your expertise to share with this group of people. I'm the president of CMS Corporation. We're a federal prime construction contractor that has grown. We have about $7.1 billion of contract capacity, and we are an example of those businesses that have navigated the small, and we now are in the other than small bucket. So this subject is very close to my heart, and one that I consider always to have been of interest to us throughout our years. And I'd like to introduce Sam Finnery. Sam provides counsel to commercial businesses in a wide range of government contracting and litigation matters. His practice includes representing the federal contractors to obtain favorable outcomes on bid protests before the GAO or the COFC, the Court of Federal Claims, and in size and status protests before the SBA and its Office for Hearings and Appeals. Sam has also extensive experience litigating and resolving claims, appeals, contract disputes, and general business torts. In addition, he advises clients on matters of regulatory compliance arising under the FAR and SBA regulations. As you can see, Sam has extensive experience, and he's a partner with Pilero Maza. Thank you, Sam, for giving us your time. Megan Limon. Megan counsels government contractors and commercial businesses on a broad range of government contracting matters. She advises companies on small business procurement matters, particularly on issues related to eligibility and participation in small business federal procurement programs, such as the SBA's small SDV-OSB, Woman-Owned Small Business, 8A Business Development, and Hub Zone programs, as well as the All Small Mentor Protege program and the VA's Vet Biz VIP program. She also assists clients in maintaining compliance with the FAR and small business regulations. Thank you, Megan, for giving us your time, and this is off to you.
Thanks so much, Mercedes, for the warm introduction. So Megan and I today, this is a little bit about our firm. as Mercedes mentioned, we represent government contractors in a wide array of matters. We also represent commercial businesses across the United States. In addition to the government contracts practice group, of which Megan and I are both a part of, we also have a litigation group, a labor and employment group, and a business and transactions group, which allows us to counsel our clients on a whole host of issues and serve as their strategic partner, whether it be government contracts issues, subcontract disputes. We counsel our clients as they grow and are going through different business transactions, and certainly as it relates to different labor and employment issues that can arise when you're working in the government contracting space. Here's a little bit of our overview for today. As Mercedes indicated, we're talking about recertification today and its impact on small businesses. We're going to start by talking about when it is exactly that a firm needs to recertify or certify in general as a small business, and the different events that trigger recertification as a small business, as well as what the effect of recertification is on small businesses, their contracts, and their eligibility for future awards. We're also going to touch upon, what it is that your competitors might be doing wrong when they certify as small or fail to certify, which could subject those companies to size protests, and hopefully give you some information on how you can keep an eye on the competition and potentially raise issues when you see them as it relates to what your competitors, might be doing to inadvertently skirt the rules and create issues that might render them ineligible for awards on which you're competing. At the end, we're also going to touch upon what the impact of failing to certify is, or more importantly, making a false certification as to your size or status. So I'm first going to touch upon the regulatory background here of the recertification rules and certification rules in general. There are a number of FAR clauses that apply here, but generally the rule is that offerors have to be registered in SAM, the System for Award Management, at the time that they submit an offer or quote. There are some exceptions here. For example, purchases under the micro-purchase threshold. There's certain classified contracts where you don't have to be registered in SAM if that would pose a national security threat or confidentiality concerns, things of that nature. And then certain, overseas contracts don't have to comply, offerors don't have to comply with the SAM registration requirement. When you submit an offer, though, you are verifying that your representations and certifications in SAM have been updated in the last 12 months, and that they're current, accurate, and complete, except for any changes that you identify specifically in your offer. And we've included in here the different FAR clauses that apply depending on the type of acquisition that you're going after. Next, I want to say that unless the acquisition is exempt, you have to, the CO is required, rather, when awarding a contract, before awarding the contracts, to go in and verify that the offeror is actually registered in SAM and was registered in SAM at the time an offer or quote was submitted. So this is just important to keep in mind. It's a pretty basic concept for companies in the government contracting space. I guess one important nuance to this is that these rules also apply to joint ventures. So you've got to be registered in SAM at the time you submit a bid for any contract that you're pursuing as a joint venture. So what are reps and certs and what's required by SAM? There's a couple of different clauses here. FAR 52.212-3 has the representations and certifications that you have to make for commercial items, and FAR 52.219-1 has the small program representation that you have to make. Essentially, you have to go in and verify your size status for all the NAICS codes that you have selected for your company, and whether you are small for those given NAICS codes, whether they be based on receipts or an employee count. You also have to check the boxes when you're filling out SAM to indicate whether you have any specific small business or socioeconomic statuses, whether that be veteran-owned small business, a hub zone entity, woman-owned small business, or just a regular small business concern. It's important to note that you can't check the box. There's no 8A box to check. You have to check small with advantage business. Also for WOSB and EDWOSBs, keep in mind that there's now a WOSB program that's a certification program. It's not simply a self-certification program anymore. So you can no longer self-certify as either of those entities. You still have to check the box in SAM, but there's now an explicit certification program for those types of entities.
Okay, so we often get a question of when must contractors update their reps and certifications? So at minimum, this needs to be done annually to ensure that it's up to date, current, accurate. I will also note that every year, as it relates to your size status can change beginning January 1st of whatever year, the next year you're in. So you have to be very careful when you're submitting bids to make sure that your reps and certs are still accurate, because a lot of times companies do move from small to other than small, or maybe from other than small back down to a small business beginning January 1. So companies have to say, well, my reps and certs aren't due till, let's say, I don't know, July. Well, so if your reps and certs are not accurate, you can't rely on, what's currently in SAM to update. So it's definitely at least an annual certification, but you want to make sure that they're current, accurate, and complete, because you do have to certify on any bid that either your SAM reps and certs are accurate, or you have to, explain which ones are not. So you have to represent, yourself as a small business, assuming a small business set aside, that you have represented as a small business. If there's been a change or something like that we will get into in the later slides, you will have to go back and update your reps and certs whenever there is a transaction or other event that requires a recertification. So a good rule of thumb is obviously annually, but anytime something changes that triggers a change, you should go in and update your SAM as well. So in terms of, okay, I've submitted a bid, then what happens, basically? So you want to look to see what FAR clauses are included in your contract, but typically most contracts include FAR 52-219-28, which mirrors essentially SBA's regulation on when re-representation or recertification is required. And under this clause, a small business concern, on any type of set-aside contract, has to re-represent, so essentially recertify, size and socioeconomic status, either within, there's three types of events. First is within 30 days after execution of a novation agreement. So if you've, acquired a contract and it's going to be novated to you, you have to then re-represent the size applicable and status applicable to that contract. The second event is whether there has been a merger, acquisition, or other transaction that doesn't require novation. So for example, a company gets acquired by another company, but is still going to continue to exist as a wholly owned subsidiary of another company. So technically the entity that was awarded the contract still exists. So you don't have to have a novation, meaning the name of the company that's performing the contract is not changing. However, because there has been a merger, essentially an acquisition by another company of that company, then the acquiring and the selling company would have to recertify within 30 days of that transaction becoming final. The other triggering event for re-representation has nothing to do with novations or transactions or anything along those lines. It applies, though, to long-term contracts, so any contracts that are more than 5 years. So this typically applies to the larger, like IDIQ or GWAC vehicles, Stars, Oasis, Polaris, CSP, whatever. Any of those, because the entire contract period could go for, longer than 5 years. It could go, some are 10, 20. This also applies to GSA schedules. You do have to recertify between 60 to 120 days prior to the end of the 5th contract year. So you want to make sure for long-term contracts that, every long-term GWAC, what have you, contract typically has different provisions in terms of whether there's like an off-ramping provision or what happens if you certify as other than small. So we'll kind of get into that a little bit later in the presentation. But the general rule of when you're supposed to do it is prior to the end of the 5th year of the contract as it relates to long terms. And if there's any other date specified in the contract for options thereafter.
Megan, I have a quick question. So if it is item 2, which is a merger or acquisition, it's a separate subsidiary that doesn't require innovation. What happens to the status for that business under those IDIQs, long-term contracts? Are they able to continue to hold them? What happens to them?
We're going to get into that in a couple later slides. So we'll get there, I promise.
Thank you.
Okay, so how does a contractor re-represent, under the FAR? So again, this comes back to your SAM registration. You need to go back into SAM and update as necessary to reflect the current status. You also have to notify the contracting officer within the specific time frame. So whether that be 30 days after the novation, the merger, the acquisition, or within that 60 to 120 day timeline, typically the government will send you a notice saying, we're getting close to the end of the 5th year, you have to provide a certification. But the FAR does contain, that very specific time frame for when you have to recertify. Sometimes companies say, well, we want to do it, earlier or later because maybe you're getting close to the end of the year and that can change the size. Your size might be changing at that point. So unfortunately, you do have to stay within that timeline. So you just want to make sure that you're, following that timeline and the regulations, updating SAM, notifying the contracting officer within the right periods of times, and so forth. So if you re-represent under the 52.219-28 as other than small. So again, this assumes that you were awarded, a small business set-aside contract. If whatever event that has occurred, whether that be the novation, the acquisition, or the 5-year, if you're no longer than small, then the general rule, and again, we recommend reviewing your contract-specific language to see if something else happens, because a lot of times there are off-ramping provisions or things along those lines. But the general rule is that the agency can no longer include the value of the options, orders, or purchases made after that point towards its small business contracting goals. That doesn't necessarily mean that you're going to lose the contract. But again, that could change based on what the contract says. But generally speaking, you can keep the contract. Agencies are just no longer able to count the value of any options or orders towards its small business, contracting goals. So within 30 days after the notification, then agencies are supposed to issue a modification to the contract to update, essentially to reflect that re-representation as other than small. And it is supposed to be reported to FPDS, which is, where the government tracks all of the contracts and where the money is flowing and the types of set-asides and things along those lines.
We have a question that just popped up on the Q&A. It says, when a business is involved in a sale or merger, is there any way to preserve the business size or socioeconomic status on existing contracts?
So this is a question I think we're going to hopefully answer by the end of the presentation, but if not, it's something we can answer specifically at the end, because there is a lot of nuance to that question, and that's a big focus of what we're trying to distill for everyone today.
Thank you, Sam.
So SBA contains very similar regulations regarding the FAR in terms of when size recertification is required. So again, it's 30 days after approved contract novation, 30 days after the final merger, sale, acquisition. We want to note that under SBA's regulation, that both the acquiring and acquired company has to recertify if each has been awarded a small business contract. So, if it's a small business buying another small business and they each have small business set-aside contracts, and that could come into play. We often get the question, well, what happens if I'm in a joint venture? So SBA's regulations were revised a little while ago to explain that if a partner to the joint venture has gone through an acquisition, then that specific party to the joint venture has to recertify, but it's not both parties to the joint venture. One other item that we want to note is that SBA added this kind of 180-day type rule to their regulations about 1.5 years ago or so. If there is a deal, some transaction that occurs after offer, but prior to award, and the transaction has occurred within 180 days after offer, and then the company is unable to recertify as small, that company is no longer eligible for award of a small business contract. If it occurs after that 180-day mark, award can still be made, but it's not going to count as an award to a small business. So SBA's thinking was to try to prevent scenarios of companies thinking, okay, I'm going to be selling, but I'm going to try to get in all of these bids really quick before I sell, so that I'll keep those contracts after award to try to maybe increase the value of the company or something along those lines. So SBA's thinking is if it's closed within 180 days, you probably knew prior to submitting your offer that this was a strong possibility. You were getting close on a agreement, something along those lines. So you want to be careful if you're entering into a transaction and you have pending bids. We need to look at when were those bids submitted and potentially what impact that could have. Again, SBA's regulations kind of follow the FAR, no more than 120 days prior to the end of the long-term contracts. You can't, do it too early. Something also to note is that contract officers have the discretion to require recertification in response to, a task order under an IDIQ contract. So the general rule is that your size and status remains throughout the life of the contract and for orders issued thereunder. However, we have seen situations, and I have seen a decent uptick in scenarios where contracting officers are asking for recertification so that they can ensure that they're getting their small business goals. So from the previous slide, we mentioned that while you may not be off-ramped, agencies are no longer cannot count your small business status towards future options or orders. So if you've recertified as other than small, the agency wants to get your recertification at the task order level to ensure that they're getting their credit. All this to be said, organic growth. So if you just grow naturally as a company, you're just doing great, everything is moving along well, you're not required to make a recertification when you get to be other than small. You just keep going. Unless the contract is, long-term contract, and then that 5-year mark, you would have to make that recertification. But there's no penalty for just growing, naturally, not through some other type of sale or acquisition.
So I'm going to touch a little bit now on what the effect of recertification is, which is certainly an important topic for today's presentation, and there's been a couple questions on this already. So what we know for sure under SBA's regulations is that similar to the FAR, and I should make a disclaimer here in that in your contract, you're very rarely ever going to have SBA regulations in your contract. It's going to have the FAR clauses, and it's most likely going to have that FAR clause 52 219-28 that Megan was talking about. That's the FAR's re-representation clause. And so therefore, as a matter of contract, you're going to have to comply with those clauses and, recertify when there are those triggering events like an acquisition or a novation. But separate and apart from that, you also, as a small business, have to comply with SBA's regulations. And it's important to note that the FAR's representation clause is modeled after, and it's supposed to mirror SBA's regulation. It was added to the FAR specifically because SBA created this recertification rule, and the FAR wanted, the FAR Council wanted consistency across the two sets of regulations. One of the problems, however, is that the updating of the FAR happens a lot less frequently than the updating of SBA regulations. So while the two sets of regulations are intended to be a mirror image of each other, they are not, because SBA has made a lot of tweaks to its rules and continues to make a lot of tweaks to its rules. And the FAR is usually years, in some cases, behind on updating their regulations to similarly, reflect changes that SBA has made. But all that is to say, currently, they both read the same way as far as what the express impact of recertification is, which is that if you recertify as other than small, as a result of the different triggering events we've been talking about today, the agency can no longer count the options or orders issued from that point forward on any long-term contracts you have toward their small business goals. And like the FAR, under SBA's regulations, you have to immediately revise all applicable federal contract databases, including SAM, to reflect your new size status. And as Megan was touching upon, if you've got, an IDIQ contract, it's possible that when you recertify as other than small, or you change your socioeconomic status, that could lead to off-ramping, which I know is a term that we've thrown around a little bit today. So for anyone that's not totally familiar with what that is, there are a number of large contract vehicles. I know Oasis is one of them, for example, that have specific contract provisions in them that would trump any SBA or FAR regulation. And by contract, they have these, they're called off-ramping provisions that essentially say, if during the life of this contract, you grow to exceed your size standard, or you go through one of these events and you recertify as no longer small or no longer the applicable socioeconomic status, you must notify the procuring agency. In Oasis, in the instance of Oasis, that would be GSA. And then the clauses specifically say, as a result of that recertification, you will then be placed in dormant status, which is what Oasis says, which is basically that you're no longer allowed to bid any new work. You can continue to perform the work you have, and once all that work's done, you'll be off-ramped permanently. Your contract, in other words, will be terminated for convenience, and you'll be done with being able to work on that vehicle. So it's important to keep, an eye on what a contract might say as compared to what the FAR and SBA regulations say more generally, because those provisions can have big implications if you're contemplating a merger, an acquisition, you're going to novate a contract, and as a result of that deal, the contractor is now going to be other than small, and they might think, this is great. I'm going to be getting this vehicle, and I'm going to be able to continue performing. Well, that might not be the case if you've got one of these provisions in there that says that, the bidding life on that contract is essentially over once you recertify.
Sam, and there's another question, and I think it goes back to the last slide from Megan, but it says, as a business organically outgrows its size standard and must recertify the socioeconomic and size standards after a 5-year period with an IDIQ, is there a way to maintain the contract even though the agency cannot count the contract toward its goals?
Sure, yeah. So, a good general rule to lay out here for everyone is that recertification doesn't trigger an automatic termination of your contract under any circumstances, except if you're an 8A entity and you go through an acquisition and you're longer 8A, the regulations do speak specifically to termination of your 8A contracts. In that instance, unless you're able to obtain a waiver in connection with the deal you're going through. But generally speaking, outside of the 8A context, if you recertify, your contract doesn't have to be terminated. The only explicit impact is that the agency can't take credit, but you can continue to perform. Generally speaking here, the agency just can't take credit. Now, the effect of that, to what Megan was saying earlier, could be that if the agency is very concerned about the ability to take credit, perhaps they could terminate your contract for convenience and just say, nope, we want to be able to take small business credit. And therefore, you've told us you're no longer small, we can't take credit, we don't want to proceed with you anymore. The chances of that happening, in my experience, are relatively remote because agencies want the work, they've already procured the work, they've got a contractor, if they're happy with you. I'd like to think that it's pretty unlikely that they're going to terminate you for convenience just on a credit issue. But as Megan indicated, another issue could be that while your contract's not terminated, this change in size status triggers, if you're talking about a multiple award contract, perhaps this triggers the agency to start requesting certification at the task order level, which would then mean that if you are no longer small and you're being requested to certify at the task order level, you're not going to be eligible to pursue those orders anymore. With the general rule being, the reason why this topic is really critical for companies is that your size is determined when you initially submit a bid with price. And for IDIQ contracts, that means that so long as you were small when you bid the IDIQ, you're generally going to be considered small for each order, even if you exceed your size standard during the life of that contract. So that's why this explicit request for task order level recertification can be so, has such a dramatic impact on your eligibility going forward, because no longer are you able to claim your status relating back to the day you bid the IDIQ. Your status, when that occurs, when there is that explicit request, is going to be determined at the order level.
Thank you, Sam.
So expanding on that last point I was just making there, how do you know if the task order recertification request has been made? This is an important topic as well, because of the impact it can have on your eligibility for a specific task order procurement. There are a couple of requirements that have to be satisfied in order for it to be clear that a given task order solicitation on an IDIQ contract is in fact requesting that you recertify at the task order level. So the request has to be explicit. It has to include the size standard in effect at the time of the certification that corresponds to the contract. But what is explicit this is what the regulations say, but what these terms mean has been expanded upon in some case law, as this has been challenged a number of times over the years and has been distilled. So to be explicit, there are a number of things that aren't explicit, that don't qualify as a task order recertification request. And a couple of them are listed here on the slide. So for example, if the agency simply sets the task order aside, checking the box saying that the task order is set aside, and they include, in this solicitation, some of the standard FAR clauses, like the SAM reps insert clause, the FAR re-representation clause. Those, just the inclusion of clauses that touch upon reps inserts and impose certain reps inserts and re-representation requirements, that's not enough to constitute a recertification request. However, there's a little bit of gray area there because explicit you don't necessarily have to use the word certify or recertify in the task order solicitation for the solicitation to constitute an explicit request for recertification. SBA's Office of Hearings and Appeals has considered, more broadly speaking, whether the RFP at large was reasonably understood as a request to certify at a task order level. And GAO has also held that an agency can, by way of an amendment to a solicitation through, perhaps a response to a question that gets asked during a Q&A, or response, and then an amendment to a solicitation can be enough to advise an offeror that recertification is being requested at the task order level. So it's a little bit vague, but I think the important thing to keep in mind is that if you've got an IDIQ and you were small when you obtained the contract and you're now not, you're no longer small, task order solicitation comes out, you just need to review those solicitations carefully and flag language that you think could be read as indicating that you're going to have to check the box that you're a small business when you bid for that task order, and that's when size is going to be determined. Because if it's true that size is being determined at the task order level, you're not going to be eligible, and you could be subject to a protest if it turns out that you are awarded that contract. A company looks at your reps and SAMs and SAM, or looks online and finds, oh, this company is actually a large business, and this task order solicitation explicitly requested recertification, so they shouldn't have been eligible for it. Some of the types of language I think that should trigger and put up a red flag for you would be if there's language in the solicitation that says, for example, the contracting officer, or rather language that says the only offers from small businesses at the time of bid shall be accepted. The word certify, recertify wasn't used in that statement, but the RFP is saying that you got to be small when you bid. So, just look through that language carefully and keep that in mind, because it can really impact the landscape on whether you're able to compete for certain orders under these long-term vehicles that can extend, 5, 10, 15 years. So I'm going to touch now upon a couple of things that are a little bit less clear under SBA's recertification rules. So, one of the questions that's been asked today is, how do I preserve my status? What happens during a novation? How do I keep my status on certain contracts? So sort of wrapped into that topic is just generally when you recertify, one of the important issues to understand is that you have clarity around what specific contracts you have to recertify for. So SBA's regulations, which speak about recertifying within 30 days of an approved contract novation, that regulation says that a contractor has to recertify its small business size status to the procuring agency, and that if they are no longer small, that agency can no longer count the options for that contract going forward. So we think that the language here suggests that the recertification in the context of a novation is limited to the procuring agency for the novated contract. So if you novate a contract to another company, that company is now the named contractor for that small business contract, and they have to recertify to the procuring agency for that contract that, in this case, if they were a large business, that they are no longer small. But then the related question becomes, well, what about that company that was novated the contract? What about all the other contracts they have? Let's say they've got other small business contracts, that they were small on, that they're still performing under, but now either as a result of acquiring this contract and its revenues, or as a result of themselves growing organically over the last couple of years, they themselves are no longer small, but they've got small business contracts. Do they have to, when they get novated a contract, also recertify their pre-existing contracts, what is referred to in this slide as their legacy contracts? And we think that if you're just talking about a novation, the regulation is written in such a way that recertification under your legacy contracts is not required for the entity to whom the contract has been novated. So that's a critical distinction, because it's important to understand the scope of recertification, because that potentially could help you if you're going through a novation, you're acquiring a contract through novation. You don't necessarily want to, unnecessarily tip off the procuring agency for every other contract you have that you're also now large, because that, as we talked about, could in theory create some issues where the agency, could now terminate your contract. They could be upset about not being able to take small business credit. So there's just a whole host of unintended consequences that can occur as a result of recertification. So being able to know when you might be able to narrow scope of that recertification is really important. So turning to the next part of the regulation that talks about recertifying within 30 days of a merger, sale, or acquisition, where novation is not required, meaning, for example, you're acquiring another company, but you're going to hold that company as a subsidiary, and they're going to remain the named contractor. This part of SBA's regulation is more broad, and it says that recertification is required from both the acquired concern and the acquiring concern, if each of them has been awarded a small business contract. So basically, both parties have to recertify. This acquisition situation does not necessarily account for an asset purchase where novation is required. So if you're going through this, this rule speaks to acquisitions, but it talks about where novation is not required. So it wouldn't capture an asset purchase where you're just acquiring some assets and a contract from a company, and that's being acquired, and that contract's being novated rather. So it can still be argued that in that type of an asset purchase scenario, the acquirer does not have to recertify its legacy contracts, as I touched on a minute ago in the last slide. But it's important to note here that the regulation was revised a couple of years ago to require recertification from the acquired concern, the acquiring concern, and then also affiliates of those entities. The reason that this change was made was that SBA didn't want companies sort of circumventing the rules by having their affiliates acquire entities, and therefore skirt their own obligation to recertify if they were just having, instead of acquiring a company directly, they have an affiliate of theirs whose receipts and employees and whatnot they have to count for size purposes. But if they had an affiliate acquire an entity, well then, since affiliate wasn't previously mentioned in the regulation, it could be argued that though they would still get the benefit of that acquisition through, being affiliated with that other entity and affiliated with that deal, they themselves wouldn't have to recertify. So SBA tweaked the regulation. They added in some language here saying that recertification is required when any of these things happen, when either a company, its affiliate, acquire or acquired by another entity. But it's important to note here, if you really want to parse the regulation, that it then goes on to speak about from whom recertification is required. And although SBA put the word affiliate in the part of the regulation that speaks to when recertification is triggered, as in when an affiliate acquires or is acquired, the part of the regulation that talks about who has to actually recertify, they didn't include the word affiliate there. So the regulation still only speaks to the acquired concern and the acquiring concern having to recertify. So, point being that it could still be argued that affiliates are not required to recertify. And then another thing to point out here is that unlike the novation rule, where you wouldn't have to necessarily recertify your legacy contracts, since this rule speaks broadly to the acquired and acquiring concern having to recertify, unfortunately, this rule requires both parties on both sides of the deal to recertify all their small business contracts. So it's a much broader obligation than what can be argued if you're just going through a novation. So now I'm going to touch upon a couple of cases that were the product of size protests that were then appealed to SBA's Office of Hearings and Appeals. And these sort of crystallize what the current thinking is on how recertification affects long-term multiple award contracts and the work that is procured under those contracts through task order solicitations. So this case here, the size appeal of Odyssey Systems Consulting Group from 2021, the end of this past year. In that case, there was a protester that argued that the awardee of two task orders under GSA's OASIS IDIQ Pool 5 small business contract, the purchaser argued that entity was ineligible for award of those 2 small business task orders because it had merged with a private equity firm a month after it submitted its bid and before it was awarded those 2 contracts. The protester, who then became the appellant at OHA, argued that this merger with this private equity firm, which rendered the awardee other than small, that merger triggered the awardee's obligation to recertify, and that as a result of that recertification, it should have rendered the awardee ineligible for award. So the protester was correct that since this was a merger, there was a duty to recertify under both the FAR and SBA regulations. And the appellant specifically in arguing that the awardee was ineligible for award as a result of this recertification, because keep in mind, we've been talking today about how, generally the only express impact is that if you recertify as other than small, it impacts an agency's ability to take small business credit. Well, as Megan mentioned earlier on, there was an update to SBA's regulations not too long ago, which, important disclaimer here, is not in the FAR yet, but it is an issue of size, so it would be governed by SBA's rules. So it's important that you're aware of this rule. So the appellant here argued that because this offeror was acquired by a large business less than a month after it submitted its bid, it should have been rendered ineligible because SBA has this new rule that says if a deal like that occurs within 180 days of you submitting your offer and before you are awarded a contract, and as a result of that deal, you recertify as other than small, which this business in this case should have presumably done, that you will be rendered ineligible to receive the contract as a small business. So seems simple enough. That's what the rule says. That's what happened in this case. It's pretty easy to connect the dots there that this company then should have been rendered ineligible for award. However, the appeal was denied, and in denying the appeal, OHA cited another section of SBA's recertification rule further down after the 180-day rule, which provides that while the provisions of SBA's recertification rule that the appellant cited here, this 180-day rule essentially, while that applies to multiple award contracts like OASIS, this other section of SBA's rules specifically says that if a multiple award contract like OASIS Small Business Pool 5B was set aside for small business, then in the case of a innovation, merger, or acquisition, where the resulting contractor is now other than small, which was the case here, this rule specifically says the agency cannot count any new orders issued pursuant to the contract from that point forward towards its small business goals. So essentially what happens, because that rule does not speak about eligibility, but it speaks only to saying that if you recertify on an IDIQ like this, even within 180 days after being acquired in connection with a task order solicitation, if you recertify as other than small, the only explicit effect outlined in the rule is that the agency can't take credit for any new orders issued from that point forward. Confusing? Yes. So what OHA did was they asked SBA to provide comments in connection with this appeal to figure out how SBA was making sense of all these regulations. And I'll note that there was a case a little bit before this case came out where OHA also looked at these recertification rules and they said that these rules are not the model of clarity. So if you're experiencing any confusion trying to listen to me explain them, just know that SBA's Office of Hearings and Appeals also thinks that the rules are rather confusing. But importantly in this case, SBA in their comments when asked about this regulation, they said that the part of the rule that I just cited, talking about what happens when you recertify on a multiple award contract, SBA said that that part of the rule is an exception to this 180-day rule. And it makes clear that when the underlying multiple award contract is set aside for small business, like OASIS Small small business pool and a firm recertifies as other than small, the firm's still eligible despite that acquisition occurring within 180 days. They are still eligible for pending and future orders, with the only express impact being that the agency can't count those towards the small business goals.
So Sam, you actually, if I may, you actually answered earlier. You said, I hope that by the end, you will have clarity on that question. You just very clearly answered that. So thank you.
Well, I hope,
regarding
I hope
eligibility.
So, yeah.
Yes, no, you did a great job. And that's not a simple case to explain. But I think that kind of brings it all together. So thank you for that. And we do have another question if you want to address that before you move on to this slide. The question is, does a long-term contract holder automatically have to recertify, or can the business wait until the recertification is requested by the contracting officer?
So important distinction here is that if we are talking about a recertification request being made in connection with a task order solicitation, as we mentioned a little earlier in the slide, that's got to be explicitly laid out in the task order solicitation. And then when you bid, that's when you're going to be certifying that you're small at the time of bid for that task order. But all of these other recertifications that we've been talking about, you know, recertifying within 30 days of an novation, recertifying within 30 days of an approved, recertifying within 30 days of a finalized acquisition, deal, or merger. And those recertifications are specifically, it's incumbent upon the entity itself to satisfy the rules and to make the recertification to the procuring agency and update SAM. That's incumbent upon you. The only caveat is that in connection with these options that are issued on long-term contracts over 5 years, before the option, the first option is a 5-year mark, and every option thereafter is going to be issued. Practically speaking, it is likely that the contracting officer will reach out to you when they're getting ready to issue that option, that 5-year option, and have this conversation with you and ask you to recertify. But if for some reason they don't, it is still incumbent upon you to recertify in connection with the issuance of that option, because the rules say that you've got to do it. There's a slight difference between SBA and the FAR, but it's generally like 120 to 60 days prior to that option being issued, you have to recertify. So to answer your question succinctly, you can wait for the contracting officer in that instance when you're talking about options on long-term contracts, but don't wait too long, because the obligation is still on you to recertify. And certainly don't wait to get prompted in connection with a novation or a merger or acquisition, because the agency might have no idea that you even went through a merger, acquisition, or novation, because that's on you to inform them of.
Excellent question, and thank you, Sam.
Yep. And so to just close out the impacts of this case I was talking about, OHA agreed with SBA's explanation of the regulation, and they further explained that it wouldn't make any sense for the appellant's argument to hold water, because if you're going to have this specific regulation that talks about what happens with respect to multiple award contracts when you recertify, and that rule goes on to explicitly say that the effect is that the agency can't take credit for new orders, there would be no reason for that rule to exist if, as the appellant argued, an entity wasn't even eligible to bid those in the first place, because it makes no sense to specifically say an agency can't take credit for orders that you're not even eligible to bid in the first place. So that was sort of how OHA came around to agreeing with SBA on this interpretation of the recertification rules. OHA has since doubled down on this. There was another recertification case that happened a little bit earlier this year where they denied, for the same reasons, an appellant's argument that a prime contractor who recertifies as other than small as a result of a merger or acquisition is not eligible to receive a small business set-aside award. These cases, they sort of harken back to a 2018 case that we discussed a fair bit at the firm, where SBA actually made a 180-degree, a completely opposite argument. They took a more narrow stance that when you recertify, you shouldn't be eligible to keep bidding. And OHA reached the same conclusion that they've reached here in that case, which then spurred SBA to tweak its recertification rules a number of times. And through all of those rule changes that we've been tracking over the last 4 years or so, we really wondered whether OHA, if presented with the same type of case again, would read the rules the same way. So the important takeaway is that under SBA's current recertification rules, if you have a triggering event like a novation, merger, or acquisition, and as a result of that, you recertify as other than small, that recertification in and of itself will not preclude you from being eligible to bid on future set-aside orders issued under any pre-existing long-term contracts that you had that they themselves were set aside. I'm going to turn things over now to Megan.
Yeah, so just to
this from a protest perspective.
Wrap up, kind of, okay, so we've gone through all of this. So, what happens? Either from, a protest perspective or, potentially false claims perspective or things along those lines. So what does all of this mean? So, we often see size protests be filed on the basis of recertification or lack thereof, meaning, the company didn't recertify when they were required to. We know they went through a transaction. They didn't, explain that. Maybe it's within that 180 days of initial offer before award scenario. So these are all kind of things to keep in mind, especially if, oftentimes acquisitions are, public knowledge, they get posted somewhere. So you just want to make sure that, the companies that are getting these small business contracts are eligible and qualify as such. So if you're thinking of filing a size protest, which would be the appropriate forum, you want to understand, when do I need to file that size protest? So as an interested party, meaning you have to be, an offeror that submitted a bid on that particular procurement or task order, depending on the situation. You can't just submit, size protests here and there if you don't have any stake in the game. But generally speaking, a size protest, as long as, you are an interested party, does need to be filed with the contracting officer prior to the close of business on the 5th business day after the contracting officer has notified the protester of the prospective awardee. So it's very important to understand that this applies. You may get like a pre-award type notice saying like notification of an apparent successful offer. That starts your clock for size protest. While that does not start your clock necessarily for a bid protest or GAO protest, you want to make sure that you are, sticking to the rules and regulations for size protest. So you can also file a size protest within 5 days of notice of the size certification that a protest concern has made, in connection with like the option period that's being issued in a long-term contract. So modifications and option you're exercising and all of that is publicly available through FPDS. So if you're aware of a transaction and the company, is coming up on the 5 years and the modification shows small business, you are permitted, assuming you hold that vehicle, to file a size protest saying, we don't think they either did the recertification at the 5-year mark or that the recertification was proper. So you do have very, very tight timelines to submit a size protest as another, government contractor, as another small business. That said, there are no time limits on size protests that could be filed by the contracting officer or SBA. So we have seen scenarios where even though the underlying size protest maybe was filed based on a task order award where size recertification was not required. Therefore, the size protest filed after that order was untimely. However, the contracting officer essentially adopts the protest as their own and then files their own protest with SBA. And then SBA has to go through and do a size examination determination for this company. So just because the underlying size protest may or may not be timely doesn't mean you're completely out of the woods, as contracting officers and SBA does have the ability to take on a protest at any time. So just keep that in mind, that if this is something that you want to protest, you do have pretty quick timelines to do so. These are some certification mistakes that could lead to size protests. So maybe you don't count for employees or revenues of affiliates. So this applies, I mean, not just in the recertification world, but generally. Sometimes companies calculate their size based on their own company, not looking at affiliates. I've seen companies calculate their size based on NAICE code specific, saying, I'm only looking at revenue, I'm getting under this NAICE code. That is absolutely not correct. Revenues, tied to novated contracts. So if you acquire an affiliate, you could be having to account for certain receipts that can affect your ability to bid going forward. You also need to account for receipts if you're involved in a joint venture. There are a number of bases to file a size protest, whether that's related to a recertification requirement or not. So it's just important to understand how to calculate size, what's included in that. And generally speaking, size protests do not have, they definitely have to be specific enough, but they don't have to be definite. Like, I know their size is, $1,500,000, $20. It doesn't need to be at that level. But you need to have a good faith basis for issuing a size protest. So if publicly available, information shows that maybe they're potentially other than small based on revenues, you could file a size protest on that basis, things along those lines. So we've seen a number of companies not know how to calculate size. So they could be, falsely certifying as to a small business when they just didn't do the calculation correctly. So it's very important to understand how to calculate size and then also have the ability to file a size protest of other companies.
Megan, you have a couple good questions on that.
Okay.
The first one is, what happens if a company submits an untimely size protest?
Size protests still get forwarded. So you file them with the contractor, they'll still get forwarded to SBA, but SBA is supposed to dismiss an untimely size protest unless the contracting officer files their own or SBA adopts one on their own. So what happens could be absolutely nothing, or it could be that someone else adopts it.
Excellent. Great question. Another question is it realistic for a law firm to put together a size protest in 5 days? If so, how in-depth are these protests? What must the small business know about a competitor to initiate a size protest?
So 5 days, if we get all 5 days, we could, definitely do that. We'll be very detailed, good to go. Sometimes we'll get, it's due the next day. So that's a little bit harder to deal with. But yes, we can absolutely assist with putting together a size protest as long as it's still timely. Depending on the level of detail, we often conduct our own research. The client has already conducted their research on, either the person that owns the business or the company that owns the business. It's just like a kind of a Google search to see what information is available that could suggest, potentially leading to an eligibility concern. So you don't have to know a lot. You do have to know enough because the protest does need to be specific enough so that it's not dismissed. You can't just file a size protest and say, I don't think they're small, the end. Like, that's not going to work. You need to be able to, present some evidence explaining why there's a potential question. Again, you don't have to be certain that they're other than small, but it needs to present at least a good faith basis to question their eligibility.
Thank you, Megan. And I did notice we're running towards the end of our session. We're past for a couple minutes, but I'll let you finish. You've had some terrific questions on this session, so thank you, but I'll let you continue.
Sure. This is our last slide, so just a couple more minutes. Okay, so what is the impact of making, a quote unquote false certification? So it depends. There's various damages that could be assessed under the False Claims Act, as well as the presumed loss rule. So the reason false is in quotes is because it may not be something that you knew, but it may be something that you should have known. And there's various tests for, does something qualify as, under the False Claims Act? How negligent were you? Did you know? Should you have known? Things along those lines. So, but assuming, there is the potential for SCA liability, you could be looking at a penalty of, about $11,000 per violation. So this means, submitting a bid, any invoice that you submit to the government, you're essentially re-saying I qualified for this contract. So any invoice could be deemed a violation because you were essentially getting money that you were not otherwise entitled to. In addition to, 3 times the amount of the government damages that the government sustained. So while $11,000 may not sound like a lot, once you start adding up, each invoice, all of these instances, 3 times the damages, things, you could be looking at a significant penalty monetarily wise for not complying with these rules and regulations. There's also the presumed loss rule, which states that in any set-aside contract, there's a presumption of loss to the government based on the total amount expended on the contract, if it's established that the company, willfully sought and received the award by misrepresentation. So this is, again, applies to the small business set-aside contracts, and it just kind of adds on to the damages. You also could be looking at suspension and debarment, other procurement fraud remedies acts, potentially criminal liability, depending on, the specific circumstances, but it is absolutely not something to be taken lightly. You want to make sure that you're complying with all the rules and regs. And if you're unsure, feel free to give us a call. But that was our presentation. Mine and Sam's emails and contact information is here on the screen. So thank you for staying a couple minutes over. But I think, Sam, do you have anything else that you wanted to close up with?
No, that was great, Megan. Thanks for taking us home.
Sam and Megan, thank you so much for your time. This was, we had some excellent questions and you did a terrific job. A copy of the webinar slides for everybody on this call are available to download under Handouts tab. If you look at the Handouts tab on our screen here, you are welcome to download it. A recording of the webinar will also be available in SAME's YouTube channel within 10 days. And the certificate, if you wish to have a certificate, will be emailed to the attendees within 2 days. And last but not least, I hope to see you all at JETSI. And again, Sam, Megan, thank you. And we will be keeping up with Pilero Maza as the years continue. Thank you.
Thank you all.
Thanks so much. Take care, everyone.